Our next presenter will be the Director of the California Office of Real Estate Appraisers, Bob Clark, who will address us on licensing and enforcement issues, as well as educational and legislative issues pertinent to all appraisers. So please join me in welcoming Mr. Clark.
Thank you. Thank you. I just appreciate the opportunity for community colleges to ask me to come and share with what's going on at OREA. I'm a huge fan of the community college system. After I graduated with a degree in economics from UCLA, I decided I wanted to go into real estate. And I didn't have any real estate curriculum in my economics degree, so I went back to Santa Monica College. It was in Santa Monica City College, and spent a year going to night class to learn about the real estate business. So it's a great system, and we just need to do whatever we can to maintain it and to keep it affordable for all the young folks out there that want to be educated. So I'm going to share with you what's going on in our office and in the world of appraisal regulation. You'll see at the bottom of my first slide here, I've got our mission statement: to protect public safety by ensuring the competency and integrity of licensed real estate appraisers. And actually, we need to change that. We need to add appraisal management companies to that. So I'm going to talk a little bit about the appraisal regulatory structure, and my colleagues at the federal government refer to the three-legged stool of appraisal regulation. We have the appraisal subcommittee, we have the appraisal foundation, and then each state has their office or board. In California, it is the Office of Real Estate Appraisers that enforces the law. The appraisal subcommittee, in 1989, Title 11 of FIREA established the appraisal subcommittee within the Federal Financial Institutions Examination Council, FFIEC. The appraisal subcommittee is empowered by Congress to oversee the appraisal regulatory programs established by states, territories, and the District of Columbia, to monitor the requirements addressing appraisal standards for federal financial institutions, to maintain the National Registry of State Certified and licensed appraisers, and to monitor and review operations of the Appraisal Foundation. The Appraisal Subcommittee are the folks, I consider them my federal boss. They're the folks that come and review our program once a year and let us know how we're doing, good, bad, indifferent. The Appraisal Foundation is a not-for-profit organization dedicated to the advancement of professional valuation established by the appraisal profession in the United States in 1987. Since its inception, the Foundation has worked to foster professionalism in appraising by establishing, improving, and promoting the uniform standards of professional appraisal practice. That is our Bible for appraisal regulation throughout the nation. Establishing educational experience and examination qualification criteria for the licensing, certification, and recertification of real property appraisers. Establishing educational and experience qualification criteria for other valuation disciplines, disseminating information on the uniform standards and the appraiser qualification criteria to the appraisal profession, state and federal government agencies, users of appraisal services, related industries and industry groups, and the general public, and sponsoring appropriate activities relating to standards, qualifications, and issues of importance to appraisers and users of appraisal services. The Appraisal Foundation now has 3 boards. Well, actually 4. They have their board of directors, of course, but the 3 boards that establish certain things. We have the Appraiser Qualifications Board. They establish the minimum education, experience, and examination requirements for real property appraisers to obtain a state license or certification. The Appraisal Standards Board develops, interprets, and amends the uniform standards of professional appraisal practice. And the new Appraisal Practices Board. It was formed by the Foundation Board of Trustees on July 1st of this past year. The APB is charged with the responsibility of identifying and issuing opinions on recognized valuation methods and techniques which may apply to all disciplines within the appraisal profession, and will offer voluntary guidance in topic areas which appraisers and users of appraisal services feel are the most pressing. And there are a few issues pressing these days. And the third leg, the Office of Real Estate Appraisers. Our Real Estate Appraisers Licensing and Certification Law was enacted by the California Legislature in 1990. Our office was established within the Business, Transportation, and Housing Agency. We are charged with developing and implementing a real estate appraiser licensing and certification program that is compliant with a federal mandate. Our licensing unit sets the minimum education experience requirements per federal and state laws. We pretty much follow what the foundation lays down to ensure that only qualified persons are licensed to conduct appraisals and federally related real estate transactions. Applicants must meet minimum education, I'm sure you're all aware of that one, and experience requirements and successfully complete a nationally approved examination. The Appraiser Qualifications Board actually validates that exam every year. There are 3 new exams for each license category that are new every single year. The enforcement unit investigates backgrounds of applicants and licensees to ensure that they are fit for licensure, and investigates complaints of violations of national appraisal standards filed against licensed appraisers. The office is also responsible, and I put this in bold because I'm speaking to real estate educators. We are also responsible for the accreditation of appraisal educational courses and providers for both qualifying and continuing education courses offered by California's community colleges and universities and 65 to 70 proprietary schools. And here we get into what the education requirements are for each level of licensure. For our trainee and residential license, they are now required since January 1st of 2008 to have 150 hours of prescribed education in these topics: basic appraisal principles, basic appraisal procedures, the 15-hour National Uniform Standards course, residential market analysis and highest and best use, residential appraiser site valuation and cost approach, residential sales comparison and income approaches, and residential report writing and case studies. To obtain a certified residential license, it takes a total of 200 hours. They have the same 7 courses that I just listed, plus statistics, modeling, and finance, advanced residential applications and case studies, and appraisal subject matter electives. There's 20 hours of those required. Plus, the certified residential also requires either an associate's degree or 21 college semester units from a regionally accredited college of each of the following subject matter courses: English composition, principles of economics, micro or macro, finance, algebra, geometry or higher mathematics, statistics, introduction to computers, and business or real estate law. Now, there was a question earlier, or a comment, are we going to just strictly a degree in the future? That is being discussed, but there's nothing set in concrete on that just yet. To obtain a certified general license requires 300 hours of education, and it's pretty much the same courses that the other ones require, except rather than residential analysis, you'll see the 4th one down: general appraiser market analysis and highest and best use, statistics, modeling, and finance. That's also what's required in the certified residential. General appraiser sales comparison approach, general appraiser site valuation and cost approach, general appraiser income approach, general appraiser report writing and case studies, and appraisal subject matter electives, 10 more hours than what's required for the certified residential, plus a bachelor's degree or 30 college semester units, again from a college, an accredited college, in each of the following subjects: English composition, microeconomics and macroeconomics, finance, algebra, geometry or higher mathematics, statistics, introduction to computers, business or real estate law, and 2 elective courses in the following: accounting, geography, agricultural economics, business management, or real estate. Continuing education. All licensees must complete an average of 14 hours for each calendar year. Continuing ed is not required to be completed in each specific year. The required continued education topics for all licensees: the Uniform Standards of Professional Appraisal Practice. Each licensee must complete the 7-hour National USPAP Update course or its equivalent as determined by the AQB every 2 years. That's because USPAP changes every 2 years. They're always tweaking it. They're always amending it, trying to improve upon it. The course must be taught by an AQB certified USPAP instructor who is a certified residential or certified general appraiser in good standing. If the update course is a distance offering, the instructor must also possess the Certified Distant Education Instructor designation from the International Distance Education Certification Council. Laws and regs. Licensees must also complete the 4-hour course entitled Federal and State Laws and Regulations, or licensees may certify that they have read and understand all applicable federal and state laws and regulations. A certification does not provide the 4-hour credit towards the required 56 hours of continuing education every 4 years. Here's what we've been doing this past year. My life this past year has been all about rulemaking and filing documents with the Office of Administrative Law. So we did a regular rulemaking filing that implemented some appraisal subcommittee requirements and an extension of the license fee reduction through June 30th of 2014. We filed that with the Secretary of State and it became effective on September 23rd, 2010. Also did an emergency adoption and 2 emergency readopts of our AMC registration regulations, extended them to last month, January. Our regular rulemaking was published on October 29th. The comment period closed on December 13th. It was approved by OAL and we filed with the Secretary of State on January 31 of this year. So our appraisal management company registration regulations are now in effect, our permanent regulations. Well, until we change them again, I guess. In this next year, we anticipate regulations will have to be promulgated upon potential legislative action that will implement appraisal provisions of the Dodd-Frank Wall Street Reform and Consumer Protection Act, H.R. 4173. I'm sure most of you are probably aware of that legislation. Here are the issues that we're looking at with the Dodd-Frank Act. Federal appraisal independent standards. California pretty well covered appraiser independent standards in 2007. In October of 2007, SB 223 was implemented, and it added financing and development to those things that an appraiser could not be influenced by a party to a transaction. Also, SB 6 was introduced December 6th and is in committee, I believe, right now, and it will bring into effect, it will copy some of the language from Dodd-Frank, change some of the language in our California statute to come more in line with the federal statute as to exactly what constitutes unlawful pressure on appraisers. Dodd-Frank also mandates a reporting of USPAP violations by anyone involved in a transaction. If you're a real estate broker and you have reason to suspect that bad appraisal work has been done, federal law now says as of April 1, you must report to the state certifying board of appraisal regulation if you see bad appraisal work. Also, there's going to be the establishment of a national appraiser complaint hotline. We anticipate we could see an explosion in this year ahead of the enforcement complaints that we receive at the Office of Real Estate Appraisers. One of my colleagues in one of the other states at our Aero conference last fall opined that they expect to see possibly a tripling of enforcement complaints coming in. California is the largest state. We do expect to see quite a few. Yes, ma'am.
Is there enough enforcers to go around?
Excuse me. We're going to ask you to speak in the microphone, please. Thank you.
I have a question. Are there enough enforcers to go around enforcing all these rules and regulations since we have such a budget crunch right now?
The question is, do we have enough enforcement staff? That is a challenge of the department. We have been able to add staff in the last several years, and we are improving, and I will show in my presentation as we move along here, we are improving our performance in the enforcement arena. We do have a challenge ahead of us, so more to come. Customary and reasonable fees to appraisers. Federal statutory language lacks sufficient clarity for us to hang our hat, I believe, on anything statutorily in California. This is an issue that came about to a large degree from the Home Valuation Code of Conduct, which promoted a lot of appraisal work to go to appraisal management companies by lenders. And one of the things that's happening is there are unethical appraisal management companies out there that are looking for the fastest, cheapest appraisal. And appraisers are a lot of appraisers are hurting, but then, two, a lot of appraisers out there are taking that $100 or $150 to do an appraisal that they used to get $350, $450, $500 for. And my admonition to the licensees out there is just say no. Mr. Appraisal Management Company, I am a professional. I had a lot of education. I had a lot of experience to get my credential. I prepare a professional report, and I expect to be compensated appropriately for my professionalism. And I know that's easy for me to say. I'm not out there in the trenches with the appraisers, but if every appraiser in the nation would do that, we wouldn't have some of the problems we're having right now over this customary and reasonable fees. Yes, sir.
I'm glad you brought that up. My name is Chris Sorensen. As an advocate for the consumer, I'm very, very frustrated about HVCC, and nothing seems to be being done about it. It's hurting the consumer is what it's doing. And while the professionals in this room obviously would applaud what you just stated, sadly, there's always going to be the lowest common denominator out there who's going to take that $150 and run with it. Everything that they did with HVCC that was supposed to protect the consumer is hurting the consumer, and nobody seems to be doing anything about it. Do you have any way to address that?
We need to be much more stringent in our enforcement efforts, and we need the help of the public to report bad appraisal work. And when a $150 report comes in and it's obvious that the appraiser spent about $1.50's worth of time on the report, I really want my investigators to see that report to get that bad actor out of this play. That's the teeth that we have as regulators. The Home Valuation Code of Conduct, in fact, I'll get into this in a moment, is actually passé at this point. There are new appraiser independence requirements that Fannie Mae and Freddie Mac have adopted, which, in fact, I've got right here. HVCC replaced by, I call it Franny now, Fannie Mae and Freddie Mac, appraiser independence guidelines, and you can see here I have the links that you can go to on the internet to pull up those appraiser independence guidelines. They pretty much mirror the same things that were in the Home Valuation Code of Conduct.
Well, that's my concern, because I've read the guidelines, and my Equitrax just reported today, it was in the National Mortgage News, that it takes 71% of all short sales take 9 to 10 months.
Yes.
10% take over 10 months. And the greatest challenge that we're having is the valuation, is that a real estate practitioner will give a market value, and they'll come back, obviously, with their desk jockey inside, sitting in Paducah, Kentucky, saying, no, the value is this instead.
My other admonition to lenders out there that are doing short sales, speed up the process. It's ridiculous to hang a potential buyer out there for 4, 5, 6 months over trying to make a decision. That's silly.
Well,
that's my opinion.
And I agree with you, but my point has to do with, all has to do with the valuation, and that's why I was pointing it towards you. I didn't know if you, I guess let me just ask this question. Should I advise the realtors and the consumers to report to you that type of poor workmanship on the part of the bank?
Absolutely.
Okay.
Absolutely. Banks do employ appraisal reviewers. Appraisal management companies employ appraisal reviewers. They're licensees as well. They are subject to our oversight. Appraisal management company registration is also mandated by Dodd-Frank. We did cover that in October 2009. And again, I mentioned our new law under SB 237. We now register all appraisal management companies. National Registry listing of appraisal management companies, and there's a question over the collection of registry fees. The way it's laid out in the federal law is so much per appraiser on the panel, and it's going to be very difficult for us as regulators to figure out how many appraisers a certain AMC has on their panel in the state of California. These are a lot of stuff that we're going to be dealing with over the next year or two that has a lot of us scratching our heads as regulators trying to figure out how to make it work. Increased resources and authority to the appraisal subcommittee. Increase in the national registry fees, this is to appraisers, is going to $40 beginning 2012. They do have the authority to raise that up as high as $80 per year for listing on the national registry. They will have the authority to do grants to states for appraisal regulation. We have some jurisdictions, I believe there's 54 or 55 jurisdictions under the appraisal subcommittee of the 50 states and then territories. Some of our very small jurisdictions really don't have enough appraisers to adequately fund a program. And so the appraisal subcommittee may be making grants to those smaller jurisdictions. And I'll get this one more, then I'll answer that question. Possible imposition of interim actions and suspensions as an alternative to the derecognition of a state agency. In the past, the appraisal subcommittee's authority has been to derecognize a jurisdiction that is not doing an adequate job of appraisal regulation. It's never been invoked. If they were to de-recognize the state of California, the resounding effect to the world economy would be devastating. To shut down all residential lending for federally related transactions in this state, it's not going to happen. So the talk in Washington, D.C. seems right now to be buzzing around the potential of fines for states that are not adequately enforcing real estate appraisal law. Yes, ma'am.
Okay, I have a question regarding not enough real estate appraisers. I have a work experience program at Cerritos College, and we cannot get any appraisers to work with any of our students as interns. So how are we going to get more appraisers if appraisers don't want to train anyone new?
It's a big problem right now. We have a number of trainees that are coming to us asking who can I get trained by, and a lot of certified appraisers do not want to take on that responsibility right now. It is a problem. I believe that we're going to see this is my opinion, I believe we're going to see another couple of years of kind of a little waffling down of the markets, and that's going to impact employment in this profession. And I'll get into some statistics here in a moment about the graying of the population that does say there's going to be opportunity in the future. So I'm going to briefly go through our AMC registration law, Business and Professions Code, Section 11320.5. It was effective January 1st of last year, no grace period provision. We began issuing certificates of registration January 21st. Regular rulemaking, as I previously said, was approved by OAL and filed with Secretary of State on January 31st. The definition of an AMC in the state of California: a person or entity that meets all the following conditions: maintains an approved list of 11 or more independent contractor licensed or certified appraisers, or employs 11 or more licensed or certified appraisers, and receives requests for appraisals from one or more clients, and for a fee paid by one or more of its clients, delegates appraisal assignments for completion by its independent contractor or employee appraisers. An AMC does not include a licensed or chartered bank, credit union, trust company, savings and loan association, or industrial loan company authorized to do business in California. Does not include, when acting under the authority of a state-issued license, any finance lender or broker, consumer or commercial loan secured by personal property, mortgage lender, residential mortgage servicer, or real estate broker, or any person licensed to practice law. Lawyers are exempt from the definition. The controlling person of an AMC means one or more of the following: an officer or director of an AMC, or an individual who holds a 10% or greater ownership interest in that AMC, an individual employed, appointed, or authorized by an AMC to enter into contractual relationships with clients for the performance of appraisal services and to enter into agreements with independent appraisers for the completion of appraisal assignments, or an individual with the authority to direct or cause the direction of the management or policies of an AMC. No individual may act as a controlling person of an AMC if either of the following apply: the individual has entered a plea of guilty or no contest to or been convicted of a felony, and we have declined several applicants based on this one clause. The individual has had a license or certificate to act as an appraiser or to engage in activities related to the transfer of real property, refused, denied, canceled, or revoked in any state. Real estate broker from Nevada who's been revoked cannot be an AMC in the state of California. Any controlling person of an AMC must submit fingerprints prior to registration and is subject to the Department of Justice and FBI background checks and subsequent arrest notification service. Required business practices of appraisal management companies: ensure that all appraisals submitted to the clients are prepared by appropriately licensed appraisers. Review and ensure that all appraisal reports submitted to clients are performed in accordance with the uniform standards of professional appraisal practice. Every renewal period, a designated controlling person must submit proof of completion of the AQB-approved 7-hour National USPAP update course. For every appraisal service request, the appraisal management company must maintain records of the date of the request, the name of the requestor, the name of the client, if different from the name of the requestor, the name of the appraiser or appraisers assigned to perform the appraisal assignment, and the date of delivery of the appraisal report to the client. These are the things that will get an AMC in trouble: the prohibited actions: withholding or threatening to withhold timely payment for an appraisal, providing to an appraiser an anticipated, estimated, encouraged, or desired valuation in an appraisal report, conditioning the amount of an appraisal fee on the concluded value in an appraisal report or on a preliminary value estimate, requesting that an appraiser provide an estimated, predetermined, or desired valuation in an appraisal report, requesting that an appraiser provide estimated values of comparable sales at any time before the appraiser completes an appraisal report. This is a big problem right now. Prohibiting a contracted appraiser client from disclosing the fee for an appraisal assignment in the body of the appraisal report. An appraisal management company may not instruct an appraiser to use this comp. That's the appraiser's call. They're the professional that's been contracted with to complete that report. Yes, sir.
On your slide, Mr. Clark, you had noted that the reports may be being reviewed at the appraisal management company. You said that was one of their functions.
I'm saying that they're held accountable to USPAP.
Okay.
And I know if I'm an appraisal management company, if I'm being held accountable to USPAP, I'm going to want a very seasoned appraisal reviewer on my staff.
Well, and my question is, are there people who could be engaged in that service who are not licensed appraisers and they're not being required to take the USPAP class?
We require one designated controlling person in each AMC.
But
We don't say you must have this USPAP class. My point is that the law states that they're held accountable to USPAP. How that all works out right now, it's too new for us to really know how
who are you going to hold accountable? The controlling person, because he's the only one who's had
The appraisal management company could lose their certificate of registration if they are not complying with USPAP. If they are submitting reports that are not in compliance with USPAP, they could lose their certificate of registration.
But you see the way it's worded, there may be a crack there that they're falling through, that the people who are working there are not versed in USPAP, who are looking at these reports, and meanwhile, the consumer and the public is going to get damaged.
Right. That's the sort of discussion that needs to be directed to lawmakers to see. I mean, perhaps our law is not strong enough to enforce. We don't know yet. It's too new. So, other prohibited actions, modifying a completed appraisal report submitted by an independent appraiser, including the permanent removal of the appraiser's signature or seal, or by adding or removing any information from an appraisal report with an intent to change the value conclusion. Requiring an appraiser to provide their digital signature or seal. However, an appraiser is not prohibited from voluntarily providing his or her digital signature or seal to another person. This is a common practice in medium to large size appraisal firms. AMCs are prohibited from removing an independent appraiser from their panel of approved appraisers without prior written notice that includes evidence which supports that the appraiser has violated the uniform standards or other applicable appraisal regulations or state statutes, or evidence which demonstrates substandard performance, improper or unprofessional behavior, or other substantive deficiencies. We do recognize we've had a number of calls from our licensees that say, I'm still on this AMC's panel, but they're not giving me any more work. So is this a weak area in our law? That's a good question. Yes, ma'am.
One moment, please. We'll have a microphone for you.
Sorry.
Thank you.
Did you tell us the requirements to become an AMC? Do you have that in the regulation? What are the requirements for AMC?
They're in the definition that I previously showed. If they do all of these things, then they are defined as an appraisal management company. So it is in our regulations, in both the statute and the regulations. So.
And one other question, I think that it's important that we either take to the foundation and see how we can get these appraisers, trainees into the industry, because somebody had to train them. No way could they get into the industry without training. So we need to really take that up with the foundation and how we can.
Part of the equation right now is getting new folks coming into this profession to be properly trained. So, and it starts, quite honestly, with you folks. It starts with good, sound, solid education. But then the second part of that is good training by experienced certified appraisers. So.
Well, can you see what the foundation can do to enhance them coming into the?
I'm not sure that that's really the mission of the foundation. It's probably more in the venue of the professional appraisal groups, such as your farm managers, rural appraisers, the Appraisal Institute, the American Society of Appraisers, professional organizations. As of February 11th, we have received 241 applications for appraisal management companies in California. We have issued 193 certificates of registration. We've had 48 formal complaints submitted. We have closed with no action 23 of those 48. There are 25 investigations going on. Actually, some of those 25 may still be in the screening stage. The most common complaints that we have received against appraisal management companies: pressure to increase values, dictating the use of specific comparable sales to increase value. Again, to me, that's a hot button. It's not the client's position to tell an appraiser what comparable sale they should use. They have hired that appraiser relying on their experience, their expertise to make that determination. Fee amount contingent upon value conclusion, removal from an AMC's approved panel without cause, failure to pay or unreasonable delay in payment, and since July 21st, when President Obama signed the Dodd-Frank Act, reasonable and customary fees. Most common complaint from appraisal management companies, mortgage brokers, and realtors against appraisers, geographic competency. We get a lot of complaints that, you know, this appraiser came from 4 counties away and didn't know what he was doing. If an appraiser lives 4 counties away, does that mean they're incompetent? Not necessarily. Not necessarily. Our competency rule from the Uniform Standards, an appraiser must, 1, be competent to perform the assignment, 2, acquire the necessary competency to perform the assignment, or 3, decline or withdraw from the assignment. Being competent, the appraiser must determine prior to accepting an assignment, that he or she can perform the assignment competently. This requires the ability to properly identify the problem to be addressed, the knowledge and experience to complete the assignment competently, and recognition of and compliance with laws and regs that apply to the appraiser or to the assignment. Acquiring competency. If an appraiser determines he or she is not competent prior to accepting an assignment, the appraiser must, 1, disclose the lack of knowledge and or experience to the client before accepting the assignment, 2, take all steps necessary or appropriate to complete the assignment competently, and 3, describe in the report the lack of knowledge and or experience and the steps taken to complete the assignment competently. Bottom line, if the appraiser is not competent to appraise in the neighborhood in which the assignment is located, they should decline it, or they better really buddy up with a very competent appraiser in that area. Here's our license statistics. As of February 11th, our license numbers are at 13,821. Almost 9,800 of those are either certified residential or certified general. We've seen a huge shift to the certified ranks since the fall of 2009, when FHA required only certified appraisers to do their work. You can see our trainee and license combined is now at a little over 29% and almost 71% for our certified levels. If you look down there, if you go down to 2007, 4 years ago, we had over 20,000 licensed appraisers in California. At that time, the trainee and AL combined were over 60%, and the certifieds combined were just under 40%. So since January of 09, we've seen an almost 22% decline in our license numbers, and since January of 07, 31.46% decline in the population. Yes, sir.
How many are you using a week?
I'm sorry.
Approximately how many are we still declining, and approximately how many a week or per month now?
The question is, how many appraisal licensees are we losing a week? A year ago, we were probably in the range of 35 to 45 per week. We've actually seen that decline flatten out lately, and we've actually had some weeks where we've seen a few increase license. I would say average over the last 3 months, 2 to 3 months, is probably more in the range of 12 to 20 per week, correct. Licensee ages. I'm sensitive to this as the graying and balding continues to come on. The graying of our population. You can see here we have 0.5% of our appraisers are over 80 years old, 70 total in the state. This is actually as of January 7th. And you can see a breakdown there. 54.82% of our licensees are more than 50 years of age. Is there going to be opportunity in this profession in the future? Yes, there is. A lot of folks are going to be retiring out in the next several years. Average age of our total licensed population is 51 years old, and the age range is 21 years old. We have 4 trainees at that age. There are young folks actually coming into the profession, believe it or not. And we have 1 certified residential gentleman who is 90 years old. And my understanding is he's working. Here are our enforcement statistics for the last 4 years. Complaints received has stayed pretty solid. 2010, we actually saw a drop off a little bit in the complaints received. Investigations completed, you'll see there's a big jump from 2008 to 2009. It's because one of the things we discerned shortly after I took this job was the office was previously screening before they opened a case, and this was really not in conformance with our statute. It says if we receive a complaint form, we are to open a confidential investigation. So 2009, 2010 numbers more accurately reflect really the investigations completed. So those years include full investigations and those that are closed at the screening stage. And you can see a breakdown there of the cases closed. We've done several things since in the last couple of years. One of them is we have a fast track program. We've actually been able to add some enforcement staff. I believe we're continuing to improve our performance in the enforcement arena, and I'm really pushing my staff to get these numbers down because I do expect an onslaught towards the middle or end of this year or certainly early next year. And you can see there the sorts of actions we take: citations, closed with no action, revocations, suspensions, state revocations, stipulated settlements, voluntary surrenders, and warnings. I started keeping track on an Excel spreadsheet. Until we get our database rebuild, which is coming in this next year, I've just been keeping track on a spreadsheet that I prepared, and these are the decisions that I've executed since July of 2009. For the last 6 months of 2009, 95 decisions, resulting in a little over $64,000 in fines, $65,000 in enforcement costs, and 1,440 hours of mandated basic education. And for all of last year, 141 decisions, resulting in almost $70,000 in fines, $92,000 in enforcement costs, and 2,670 hours of imposed basic education. Pending investigations, we hit, during my experience there, our high on May 8th of 2009, 434 open cases. As of February 11th, our numbers were down to 233 open cases. And my cap is off to my enforcement staff. To me, this is exceptional performance given the fact that we've been furloughed 3 days a month for a good part of the last couple of years. I'm very proud of this. This is an excerpt from a letter that we received from the appraisal subcommittee following our 2009 review. As detailed in the attached follow-up report, California resolved one of the two concerns identified in the January 19, 2010 compliance review report. California also made significant progress toward addressing the second concern identified, that is timely closure of cases. In addition, California addressed recommended actions to strengthen the program. We commend California's program for its efforts and the progress made. My goal before I leave this job is I want a clean bill of health from the appraisal subcommittee that says we're hitting on all the cylinders and we're not violating any of their policies and standards. And I believe we can get there with the efforts we have going right now. Our priorities for 2011: to provide technical expertise to legislative staff for implementation of the Dodd-Frank Act, to maintain appropriate staffing levels in order to ensure compliance with the appraisal subcommittee standards and requirements, and to administer a vigorous enforcement program by appropriately disciplining unethical appraisers that violate the uniform standards or other applicable laws. These are public reprimands, would include revocations, surrenders, or suspensions, or recommending appropriate educational or mentoring measures for minor violations of appraisal standards. This would be non-public discipline, would include a citation, fine, education, and/or a warning, and to initiate a licensing audit program to ensure competent ethical appraisal practice. DRE has had an audit program, I believe, for a number of years. I'm not sure, Shelley, is that still ongoing, the audit program? And I believe it's an effective deterrent to bad professional work. And it's something we really want to do at the Office of Real Estate Appraisers. Our IT priorities, a redesign of our website. We have a contractor working with my deputy director and our IT staff right now. We will be launching a new website January or February of this next year, which will be, website. Let me back up here. Our website, actually, we posted the new one Tuesday of this week. It was up for about an hour, and we had to take it down because we had some technical glitches, and it should be back online on this next Monday. Okay, and then upgrade to a more robust database system. That's the effort with our contractor. Our database system is dated. We really need a much more effective, more robust database system. We want to expand our online licensing functions to include all renewal and initial appraisal applications. We want to convert file storage from paper files to secure electronic database system. And we need automatic notification, and this is the one for you folks, to our Office of Continuing Education Completion by education providers. The DMV has had the smog check little blip that comes from the mechanic for, what, 20, 25 years? We really need to step into the 21st century, and we need to partner with educators to get such a system installed so we don't have to be receiving. You don't have to be sending out the completion certificates. I'm going to go real quickly because I think we're a little... Yeah, we have some questions. Okay. Conduct section of the ethics rule. These are the issues that appraisers must look for. Appraiser must perform assignments with impartiality, objectivity, and independence, and without accommodation of personal interests. An appraiser must not engage in criminal conduct. Scope of work for each appraisal review, and appraisal consulting assignment. An appraiser must identify the problem to be solved, determine and perform the scope of work necessary to develop credible assignment results, and disclose the scope of work in the report. Fraud, we're seeing a lot of fraud. That is wrongful or criminal deception intended to result in financial or personal gain. Things intended to deceive. I think we all know what fraud is. This is what we see: appraisers' complicity in fraud. Predetermined values due to client pressure. Misrepresentation of relevant property characteristics. Failure to disclose sales listing histories. Intentional misrepresentation of sales comparables. The most common residential deficiencies we see, which is the vast majority of the complaints that my enforcement staff handles. Standards Rule 1, misrepresentation of site and building physical characteristics, lack of permits on improvement additions, inaccurate zoning references. A lot of appraisers need to understand R1 is not a catch-all for every residential area of the state of California or in every county. Standards Rules 1-3A, failure to accurately analyze market conditions, failure to analyze legal conformity. 1-4, verification of information, often inadequate, understanding what primary versus secondary sources are, omission of relevant comparable sales, cost references not understood nor adequately supported. 1-5, failure to analyze current listing or past sales history, and then Standard Rule 2-3, false certifications. You're not appraisers in here. Well, there's a few I know, but these are our standards. Always comply with USPAP. Basically, be ethical. How many ways, shapes, and forms can we say? You need to be ethical, you need to be competent, and you need to make sure you're doing good, competent work. And observe the primary tenets of the conduct section of the ethics rule: objectivity, impartiality, and independence. Here is our new website, which, again, was up a couple days ago for an hour. And you'll see, if you go next to this, if you got this smiley face next to Mr. Frump, you click on that. And that will take you to this page, which is our complaints. And from there, you can click on one of those, and that's our complaint form. And we desperately need help in the complaint area. This describes our complaint process. I know we're pressed for time, so I'm going to just kind of breeze through this. This is our administrative law process. We basically go before an administrative law judge if we have a complaint, an action that's going to accusation where we're going to seek revocation. And these are all the various things. This step will be online, and so I assume we should. Yeah. Okay. Let me go through 2 case studies real quick. We need your help. If you see bad appraisal work, you know professionals out there that are seeing bad appraisal work, please, please, please submit the complaint. As of April 1st, by federal law, you're mandated to. I'm going to go through real quick just 2 case studies of what we see. Respondent purchased a home in 2006 for $570,000 with 100% financing. Sold 7 months later to a straw for $855,000 with 100% financing. The respondent prepared the appraisal report for the sale, forging the name of a former trainee who was the complainant, as the respondent had been removed from the lender's list. In conference, respondent stated this was acceptable as long as the value was there. Respondent justified the increased value, $285,000 over 7 months, by claiming construction of a 390 square foot addition, which cost $100,000 to $120,000, that his profit was only about $50,000 to $60,000. Respondent served as the seller, the licensed realtor, the appraiser through a forgery in the sale transaction, and as the property manager after the sale, renting the property. The tenant stated the respondent was their landlord. Lender foreclosed 15 months later, subsequently sold for $450,000, suffering a loss in excess of $405,000. Respondent admitted guilt, resulting in stipulated settlement for surrender of license. We are currently cooperating with DRE and the district attorney in that county in separate investigations for real estate violations and possible criminal conviction. This individual may do time. Day 1, second case, complainant received 2 telephone messages from a respondent who reportedly had a business proposition for the complainant. Respondent was a former trainee. The complainant had stopped supervising several years previous due to poor quality of work. Day 2, complainant returned the call and learned respondent had signed the complainant's name on an appraisal report for a purchase 2 days previous. Complainant went ballistic and didn't entertain the business proposition. Complainant had police contact respondent. Respondent subsequently admitted to forging the complainant's signature on the report, stating the need to make ends meet following the HVCC. Complainant contacted another former supervisor of the respondent and found that the respondent had also forged that appraiser's signature. REA investigator had proof of the 2 forgeries prior to the conference. In conference, the respondent admitted to only 1 forgery. Upon seeing the notarized admission of the second forgery, respondent admitted guilt, which resulted in a stipulated settlement for surrender of license. The individual is no longer a licensed appraiser. Questions?
We have a few questions from our friends out in cyberspace. Number 1, with the generally low fees, where are we going to get qualified new licensed appraisers who will be getting into this profession? So this individual is concerned with the low fees received by real estate appraisers for their work.
I think I kind of briefly hit on that a little bit earlier, and it's important for appraisers to demand a professional fee for their work. And we're in a tough time right now because appraisal management companies, unethical ones, are kind of wagging the dog a bit, and this needs to stop. And appraisal management company regulation is new. We don't have enough history with it yet to really get our arms around it. As I had on the previous slide there, we do have a number of complaints and we are investigating those, and it is a high priority for our office. But if you, again, you look at those statistics on the graying of the population, there is going to be opportunity in this business again in the future. It's hard right now. Our numbers are down, and they're going to probably continue to be down for a while. But we've actually seen, as I commented earlier, a flattening of that decline, and we're actually seeing, I know that there was a question we had from someone from the Inland Empire concerned about the real estate education program. We close to, in the Inland Empire, Riverside and San Bernardino counties, we had since January 1 of 2010, we've had roughly 50% of the appraisers in those 2 counties renew their licenses. This is a good sign because we're on a 2-year renewal cycle. I mean, statistically, maybe half and half. So I think a lot of people are staying in it. They do see that there's going to be opportunity in the long run.
Very good. Another good question from the internet. Address the BPOs that realtors have a vested interest in writing a BPO and then listing the property for an additional commission. Why are BPOs allowed in the process at all?
That's a question for lenders and their underwriting procedures. I personally feel any lender that uses a BPO to make an underwriting decision deserves to be out of business. It's not prudent to use a BPO to underwrite a loan. It requires a professional analysis by a licensed appraiser to really do appropriate risk management. And that's one of the reasons why our nation is in the problem we're in right now. The baby was thrown out with the bathwater with the whole subprime meltdown, and we need to get away from that. We need to get our arms around this problem and solve it as a profession, not just appraisers or realtors or, lenders, and everyone have to come to the table and address these issues and talk about how we don't repeat the mistakes of the past.
Excellent. I like that hard stand. The last question from the internet is registered AMCs in OREA's website are some of the lowest paying. Any solution to cleaning up the list?
Just say no. Again, that's easy for me to say. I'm maybe a little more cantankerous than a lot of folks out there, but AMCs have to recognize the professionalism of licensed and certified appraisers, that they have been properly educated, they have been properly trained. For our office as regulators, the only hammer we hold is appropriate enforcement of bad appraisal work and starting that audit program and getting the word out there. I mean, quite honestly, I'm dying to see where our regulation of appraisal management companies, just how that's going to kick in. And it's a big unknown legal question at this point because it is new. So until such time as we're actually in the accusation stage against maybe a violation of our new law by an appraisal management company, it's a really hard thing for me as an appraisal as a regulator to address. So, yes, sir. Were there more there, Carol?
You alluded to auditing of licensings.
Yes.
Could you further explain what you envision that may entail for
Yes.
those of us who are in practice?
The question is the auditing of licensed appraisers, and what that means is a random audit where we have enforcement staff that is dedicated to calling up a licensed appraiser and saying, we're going to be in the neighborhood next week. We would like to come by and take a look at your work log. We'd like to see some of your work samples. We want to see what we can do to help you become a better appraiser. Quite honestly, it doesn't please me, unless we've got a real criminal in front of me. I don't like taking people's livelihood away from them. If we get to an accusation stage, that individual probably needs to go. But some of our best success stories are when we've meted out minor discipline where that appraiser becomes a much better appraiser and a strong contributor to the appraisal profession. To me, that's the success. Yes, sir.
Is there any thought to restricting information about the purchase price from appraisers? I mean, doesn't that, once they know that information, I've always wondered why they should be given that information, given that it's undoubtedly going to have an influence on them.
I used to, when I was a staff appraiser with Calfad Bank, way back in the Pleistocene era, I used to tell my supervisor, you know, I don't really want to know what the sale price was. This is before we had USPAP or regulation or anything. Because I said the market needs to tell me what the sale price is. However, the uniform standards do provide that if there's a sales contract, the appraiser is to analyze that sales contract as part of their analysis, or they're to divulge the steps they took and why they didn't get to see the contract. So it is a requirement of USPAP to actually analyze agreements of sale. Yes, sir.
Bob, I have a couple of more questions from our internet participants. And one of them is, does REEC have any lobbyists up there trying to lobby for higher fees paid to the actual appraiser who does the appraisal?
REEC does not. We are a regulator. We are a State Department. We basically fall under the federal guidelines of regulation. The appropriate venue for lobbying for the appraisal profession, again, are your professional organizations such as Farm Managers, Rural Appraisers, ASA, the Institute, your Real Estate Appraisers Association, so on and so forth. And there are lobbyists that actually do work for some of these organizations that are carrying the ball for appraisers in Sacramento.
Another question I have is from Kelly, who's an appraiser and appraises primarily in rural areas. And many AMCs offer 48-hour turnaround. And sometimes due to weather or if it's an REO for access, they just cannot prepare a professional quality appraisal in 48 hours.
That's a problem, and appraisers need to let the AMC know. I've actually heard of cases where AMCs have done this and where the appraiser has gotten back to the AMC and said, you need to understand something. This is a rural area. This is a very difficult assignment. Comparables are very hard to come by. You need to try to educate the AMC. If they just won't hear it, I personally, if I were that appraiser, I would say, you know what, ABC, AMC, I no longer work for you. You're asking me to do something that is unreasonable. You're, in essence, asking me to violate the law. If I don't have the time to do a credible analysis, how are you conforming to the uniform standards, which California law requires you to do? And again, it's an education process for the appraisal management companies, and we need to get the word out on that. I don't know if that adequately answered the question, but any others?
Any other questions?
Will your slideshow be on Carol's site?
Yes.
I'll do that. Thank you for the question. The question is will this slide presentation be up on the Real Estate Education Center site? Yes, I just texted my webmaster, and she writes back, sheesh, Carol, I'm putting them up as fast as you send them. So, indeed, when we take a break, I will blast this off to the webmaster, and it will be up on the Real Estate Education Center website probably within the next 23.5 minutes. Thank you. Are there any further questions? If not, we want to thank very much Mr. Clark for your time with us.